Oh, yes, oh, yes, oh, yes. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning and welcome to the morning session of the Tennessee Court of Appeals. I want to tell you, first of all, we appreciate you participating in these appellate arguments by way of Zoom. It is not the way we would prefer to do it, but we don't always get to do what we want to do, and this is by far the safest way to do it, I believe. So thank you. We appreciate you and your clients agreeing to participate in this manner. Just before we get started, I want to go over the ground rules a little bit. First of all, let me introduce the panel for this morning. Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. I assume that each of you know that you get 15 minutes to make your oral argument. If you are the appellant and you wish to reserve any rebuttal time, you need to request that from the court after you've introduced yourself and before you begin your oral argument. You may reserve up to 5 minutes of rebuttal time, and obviously the appellee gets no rebuttal time. I want to thank the clerk staff, Jim Hibner, and we have with us today our deputy clerk, Angie Dempsey. They make this work, and it's not an easy process sometimes, and we appreciate everything they do. And we also want to thank the AOC's technology staff. They do a wonderful job as well. So, Angie, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the first case, please.
Camille Black versus Maryam Kale.
And we'll hear from the appellant.
May it please the court. My name is Brittany Smith and I represent Ms. Camille Black and the appellant in this matter. Your Honor, I would like to reserve 3 minutes of rebuttal time.
Yes, ma'am, you may proceed.
The appellant respectfully asks this court to reverse the Shelby County Circuit Court's decision and find that the amended complaint does relate back to the date of filing for the original complaint and find that it was timely filed in accordance with Rule 15.03. As noted in the appellant's brief, the applicable standard of review for this matter is de novo review. The trial court's grant of defendant's motion to dismiss involves a legal conclusion and is subject to de novo review with no presumption of correctness. Your Honors, this case is about an automobile accident that happened on May 11, 2018. The appellee, Ms. Maryam Kale, improperly exited a private drive and struck appellant's vehicle on the rear driver's side. Due to this collision, Ms. Black sustained injuries for which she sought treatment. Ms. Black was subsequently involved in another accident with Mr. Taylor Tonneson on March 20th, 2019. On May 8th, 2019, Ms. Black filed her complaint, mistakenly naming Mr. Tonneson as the at-fault driver in her subsequent accident. All of the allegations and claims made in the original complaint were pertaining to the May 11, 2018 accident with Ms. Kale. The only issue with the original complaint was the name of the defendant. 1 week later, Ms. Black realized her mistake and immediately amended her complaint to name Ms. Kale as the proper defendant in accordance with Tennessee Rules of Civil Procedure Rule 15.01. The only thing that changed in the amended complaint was the name of the defendant. All details pertaining to the place, time, and manner of the accident remain the same. On July 25th, 2019, Ms. Kale filed her motion to dismiss, citing Rule 15.03, and Ms. Black's case was subsequently dismissed. The court in Lease v. Tipton provides that the relation back feature of Rule 15.03 works only when the following conditions exist. Quote, the claim must arise out of the same conduct, transaction, or occurrence involved in the original complaint. The party to be brought in by the amendment must not be prejudiced in maintaining its defense. And the party to be brought in by the amendment either knew or should have known it would have been sued had it not been for a misnomer or similar mistake, end quote. Tennessee courts have exhaustively explained the rationale behind Rule 15.03. As provided by the court in Doyle v. Frost, the goal behind Rule 15.03 is to ensure that cases and controversies are determined on their merits and not upon procedural niceties or legal technicalities. Rule 15.03 is to be construed liberally in order to promote consideration of the claims on their merits. The court in Doyle further provided that the purpose of the relation back statute is to enable a plaintiff to correct a pleading after the statute of limitation had run, if the correction will not prejudice his adversary in any way. Further, the court in McCracken versus Brentwood provides that, quote, to avoid the statute of limitation extinguishing their claim against a misnamed defendant, Rule 15.03 permits plaintiffs to amend their complaint to correct the misnomer and provides that the amendment will relate back to the original date of filing.
What do you believe the trial court's rationale was granting the motion to dismiss?
The trial court found that the plaintiffs did not meet the mistake requirement of Rule 15.03.
And did the trial court explain that's reasoning?
In the trial court's order, she stated that, quote, plaintiff offers no explanation or even argument as to how she made the mistake concerning the identity of the proper party. But this is not a requirement of the rule. The rule only requires that a mistake was made and the proper party knew or should have known.
Okay, let's explore that a little bit. What's the legal definition of a mistake?
The plain language definition of a mistake, as defined by Merriam-Webster, is a wrong judgment, a wrong action, a statement proceeding from faulty judgment, inadequate knowledge, or inattention, which in some is simply an error.
So, and was there an evidentiary hearing, or were affidavits submitted, or what did the trial court have in front of it to consider?
The trial court only had the defendant's motion to dismiss and the plaintiff's response to that motion. There were no affidavits submitted.
Of the trial court, is that correct?
Yes, Your Honor.
No affidavit or anything explaining any of this?
No, Your Honor.
Okay.
Yes, but I would submit to the court that explaining the mistake is not a requirement of Rule 15.03.
Well, just playing devil's advocate here, how does the trial court know that it's a mistake if there's nothing in front of it for it to consider?
Well, what was placed before it was that the wrong defendant was named. Therefore,
how does the trial court know that if there's no affidavit or no evidentiary hearing?
They only have the word of plaintiff's counsel.
Which is not evidence. We have held several times the statements of counsel, not evidence. It's just argument.
That's correct, Your Honor. But just to say that, well, with regard to that mistake requirement, I would also submit that it has more to do with what the defendant knew as opposed to what the plaintiff knew.
Again, what evidence did the trial court have in front of it about what the defendant knew or what the plaintiff knew?
The trial court only had the pleadings. They didn't have any affidavits or anything like that, Your Honor.
Okay, thank you.
Ms. Smith, the Vincent versus CNA case that the trial court cited, I believe, in its order and referred to, how do you interpret the holding of that case as it relates to your position in this argument?
I honestly believe that it supports our argument, Your Honor. The court in Vincent versus CNA Insurance ultimately held that the plaintiff was able to amend her complaint to add the driver of the vehicle as opposed to the auto insurance carrier. And they did allow for the amended complaint to relate back to the original date of filing. I would say that it's very analogous because she improperly named the defendant and the court allowed her to fix that mistake because there was no prejudice to the defendant. The defendant had proper notice of the lawsuit and it all stemmed from the same transaction, conduct, and occurrence. So I believe that it does support our position here.
Thank you.
Thank you. And as I previously mentioned, there are several different components of Rule 15.03. As I stated, the amended complaint must arise out of the same conduct, transaction, or occurrence, which we have here. The only thing that changed in the amended complaint was the defendant's name. The claims alleged in the amended complaint were not changed, nor were any of the details of the accident. Second, there must be notice to the new party. Under Rule 15.03, the amendment must be filed within 120 days after the commencement of an action. And here, Ms. Camille was served 45 days after the original complaint was filed. She was almost immediately served with the amended complaint after the summons was issued. And then the next requirement is that the adverse party is not prejudiced by the filing of this amended complaint. And she had proper notice and she had ample time to maintain a defense against this lawsuit. And just to circle back around to the mistake requirement, as I previously stated, I believe the appellant submits that this is where the lower court made its error. The lower court misinterpreted this part of the rule. This part of the rule is less about the mistake made by the plaintiff. It has more to do with whether the party knew or should have known. But for the mistake, the action would have been brought against them. It's clear that Ms. Camille knew about this personal injury claim and that she was the proper defendant to be named. Because like I said, all of the facts regarding the accident, the time, date, location, and manner of the accident involved the accident that Ms. Camille was involved in with Ms. Black on May 11, 2018. And to say that Ms. Black did not mistakenly name Mr. Tonneson in her original complaint would be to infer that the decision to name him was intentional, which in appellant's opinion doesn't make any logical sense. Ms. Black was injured as a result of Ms. Camille's actions and was seeking to be compensated for the injuries she sustained. Why would she intentionally not name Ms. Camille as the defendant in her suit? It was clearly a mistake on Ms. Black's part, and she corrected it immediately. And as we previously discussed, the courts speak through their written orders. And although there are several parts set forth in Rule 15.03, the only part that the court took issue with was the mistake requirement. And we would submit that the lower court was improperly adding additional requirements to Rule 15.03 when it stated that the plaintiff offers no explanation or even argument as to how a mistake concerning the identity of the party was made. And we would submit that the case that the court cited actually supports the plaintiff's position, the appellant's position, that she should have been allowed to amend her complaint to add the correct defendant, and that amended complaint should relate back to the original date of filing. And just to address some of the arguments that were made by the appellee, Ms. Camille, she attempts to use Grantham versus Jackson-Madison General Hospital to show that a mistake requirement means more than the mislabeling of a proper party, because the notice and knowledge requirements of Rule 15.03 do not apply to attempts to simply correct the mislabeling of the party. But the court in Grantham ultimately found that the plaintiff was allowed to amend her complaint to correct this mislabeling. And the court did allow the amended complaint to relate back to the original date of filing. And for these reasons, Ms. Black respectfully asked this court to reverse the Shelby County Circuit Court's decision and find that the amended complaint does relate back to the date of filing of the original complaint, and find that it was timely filed in accordance with Rule 15.03. Thank you.
Thank you. You have your rebuttal time. We'll now hear from the appellate.
Thank you, Your Honor. My name is Chris Sobczak, and I represent Ms. Mula. I'm from the Shelby County Bar. Your Honors, I think that when Ms. Smith said procedurally how this accident occurred, the filing, all that is correct. The dates are there. However, the biggest instance and argument in this case is the two-prong test of Rule 15.03. I think that's a big crux of this. There's two parts of this. One is that the defendant received such notice that it won't be prejudice on the merit, making a defense on the merits. And it says, and two, knew or should have known that for a mistake concerning the identity of a proper party, again, a mistake concerning the identity of the proper party, action would have brought against that party. In our original motion, Your Honor, we went through this. There was a police report generated from this accident on May 11, 2018, which had Miss Mula Kell's name on there, in which the plaintiffs had. It was in their possession. We've talked about this. And so they knew that proper identity of the defendant in this case.
Let me stop you and ask a question. I've heard the appellant's response. What did the trial court have in front of it to consider at the time your motion to dismiss and the appellant's response was made? Were there affidavits? Was there any kind of evidence that the trial court had that it was required to consider?
Yes, Your Honor. We did not provide an affidavit, Your Honor. However, we provide the police report that was generated for this accident and also a letter.
Stipulation as to the validity of the police report, because obviously a police report doesn't come in as evidence.
Correct, Your Honor. There was not, but there was also a letter that was sent from Ms. Smith's firm to the insurance carrier in this case, Your Honor, with the name of the defendant, Ms. Mula Kell, on there. It's from their firm, Your Honor.
Well, would it be safe to say, and I don't want to put words in either one of your mouths, but no evidence, there was no affidavit, there was no evidentiary hearing, there were no stipulations about any exhibits being introduced for the trial court to consider. Basically, you just had oral argument over a motion to dismiss and why the case shouldn't be dismissed and why a amendment to the pleading should be allowed. Would that be accurate?
I think that's accurate, Your Honor.
Okay, thank you.
Yes, sir. As I said, in the hearing, there was a letter sent from Ms. Smith's firm to the insurance carrier stating the defendant's name on there as well. So there was no mistake concerning the identity of the proper party. They know who the defendant was at the time of the original filing, but there was a mistake. And there was I think it was mislabeling is the best way to put it. And as we stated, Grantham versus Jackson Madison County Hospital says that there must be more than a mere mislabeling of a party for an amendment to relate back. And so with that, we asking the court to affirm this order. Further, it also in Sally versus Barrett, the plaintiff has the burden of showing that the failure to name the new defendant in the original complaint resulted from a mistake concerning the identity of the proper party. Well, as just after, as you just said, there was no affidavits, there was no proof given to why they mislabeled this party. And so therefore, the burden is on the plaintiff to do this, Your Honors. So we feel that the complaint does not relate back to the original filing, Your Honors, and that Rule 1503 does not apply in this case, and that the court's verdict should be affirmed.
Let me ask you, counsel, how do you explain the Court of Appeals decision in Vincent, McCracken, and Dole, where the wrong party was sued, and yet the amendment and the relation back of the amendment was allowed in all of those cases?
I'm not sure, Your Honor, on that. I have not had a chance to thoroughly vet those cases, Your Honor. However, I would say that in this case, there was no mislabeling. There's mislabeling. There's no mistake.
No, my question was, there was a mistake. They clearly, in all three of the cases, and certainly you've read Vincent,
Yes,
where
sir.
the wrong party was sued, and yet the amendment relating back was allowed by the Court of Appeals, not only in Vincent, but also in the other two cases that I indicated. How do you explain that?
I can't, Your Honor. I mean, I don't know exactly why they did that.
But you do know that they did that, right?
Yes, I do, Your Honor.
Okay.
Yeah. But however, I think in this instance, it's different because we have a mislabeling, Your Honor. There was no mistake as to who Miss Mula Kell was. There was no mistake. They knew exactly who she was. They put the wrong person on there. That's a mislabeling of the parties. That is not a mistake as to the identity of the parties.
Well, in Vincent, they sued the insurance company. They didn't even sue the defendant driver. And yet they were allowed to amend and add the defendant driver, and the Court of Appeals decided that that amendment would relate back and the case would not be dismissed based on an expiration of the statute of limitations.
Yes, Your Honor. But, Your Honor,
Same thing in Kraken. They sued the wrong entity.
right. I think I think the difference is, Your Honor, is there's entities. I don't know that they knew who the proper party was to be sued, but in this case, they knew who the proper party to be sued was, Miss Mula and didn't do it. I'm not sure. I think it was in the insurance company case, they didn't know the identity, if I remember right, of the driver or the insured. In this case, Your Honor, they did know that. They knew who Miss Mula was. There was no mistake as to her identity at all. So, Your Honor, again, we're asking the court to affirm the lower court's decision in this case, and hopefully the case and ask that the relation back not take place.
All right, sir.
Right. Thank you, Your Honor.
Seeing no other questions, we will hear from the appellant in rebuttal. You may proceed. I think
Thank
there you
Your
go.
Honor. Oh, sorry.
That's okay. You were muted for a moment.
Yes. So the appellee cited Jenkins versus Carruth in their brief. And I would note that in that case, the Jenkins court clearly stated that an amendment, quote, an amendment relates back only to matters relating to the original parties of the complaint, or to correct a misnomer or misdescription of a defendant, and not to add or substitute a new party defendant. During appellee's oral argument just now, he cited Sally v. Barrett, but I do believe that that case is distinguishable from the one in front of the court today, because the plaintiffs in that matter were not simply seeking to correct the mislabeling of the defendant in that matter. They were seeking to add additional defendants in that matter and seek additional claims against those additional defendants. They were seeking to add a municipality to the claim along with the offending party. So I think that that's clearly distinguishable, and he can't use that to compare the two cases because they're not the same. Also, I would submit to this court that Rule 15.03 was created for situations like the one before you today. It was created to allow a party to correct these kinds of mistakes. Rule 15.03 provides a remedy for these kinds of mistakes, and the lower court misapplied this rule. The lower court's ruling should be reversed because it runs directly contrary to the purpose and intention of Rule 15.03. The lower court is essentially deciding the case on legal technicalities and procedural niceties as opposed to the actual merits of the case. To extinguish Ms. Black's claim would and not allow her to have her day in court due to a mistake that did not prejudice anyone is not the intent of Rule 15.03. And once again, Ms. Black would respectfully ask this court to reverse Shelby County Circuit Court's decision and find that the amended complaint does relate back to the original the original data filing for the original complaint, and that it was timely filed in accordance with Rule 15.03. Thank you.
Let me ask, how did you establish there was no prejudice to the defendant?
Well, the case is actually analogous to Vincent versus CNA Insurance, and in Vincent versus CNA Insurance, they found that there was no prejudice to the defendant there. And the facts that they cited in support of that was that the defendant driver was well aware of the accident at the time it happened. The insurance company had settled the property damage claim, and they were in active negotiations regarding the personal injury claim. So in conjunction with her being served within 45 days, I believe that all of those facts are in place here as well. Therefore, just like in Vincent, Ms. Kell wasn't prejudiced either.
Anything else for the appellant? Okay, thank you very much. We certainly appreciate your argument. Again, we appreciate you participating via Zoom. We will endeavor to get you an opinion on this matter at the earliest possible time. Angie, I believe that concludes this matter, and we will be in recess to the call of the 10 o'clock docket.
This honorable court is in recess until 10 a.m.
Thank you again, folks.
Thank
Your
you.
honors.